All rise. Will.
The other judges of the appeal chamber on this appeal are Judge Sylvia Fernandez de Gourmendi, Judge Christine van Weinert, Judge Howard Morrison, and Judge Peter Kovac. May I ask parties and participants to introduce themselves for the record, starting with the Office of the Prosecutor, please.
Good afternoon, Your Honour. Helen Brady, Senior Appeals Counsel, appearing on behalf of the prosecution. And I'm here today with Mr. Anton Steinberg, Senior Trial Lawyer, Mr. Matthew Cross, Appeals Counsel, and Mr. George Manguana, Appeals Counsel. Thank you.
Thank you very much. And defense for Mr. Ruto.
Mr. President, good afternoon. Mr. Ruto is represented by myself, Kareem Khan of Queen's Counsel, along with Mr. Esafal, Dato Shamla Alexandra to my right, our legal assistants, Ms. Shalini J. Raj, Ms. Clara Rodriguez, Ms. Grace Sullivan, and at the back, our two hard-working interns, Ms. Farah Mahmood and Mr. Bart Van Hattem. Thank you.
Thank you very much. Defense for Mr. Sang.
Good afternoon, Mr. President. I'm here. My name is Caroline Buisman. I'm here representing Joshua Arab Sang, together with Marie-Ange Okwegise and Cynthia Bondi.
Thank you very much. And legal representative for victims.
Good afternoon, Mr. President. This is James Mawera. I'm the case manager for the legal representative for victims.
Thank you very much. Today the Appeals Chamber is delivering its judgment on the appeal of Mr. Ruto and Mr. Sang against the decision of Trial Chamber 5 entitled Decision on Prosecution Request for Admission of Prior Recorded Testimony rendered on 19th of August 2015. In today's summary, I will refer to the decision as the impugned decision. I shall now summarize the Appeals Chamber's judgment, which was taken anonymously. The summary is not part of the written judgment, which is only authoritative account of the Appeals Chamber's ruling and reasons. The written judgment will be made available to the parties and participants at the conclusion of this hearing. By way of procedural background, the present appeals arose out of a request by the prosecutors filed on the 29th of April 2015 to admit prior recorded testimony of a number of witnesses for the truth of its contents under amended Rule 68 of the Rules of Procedure and Evidence, or alternatively under Article 69, paragraphs 2 and 4 of the statute. Following responses by the accused and the receipts of further oral submissions from the parties and participants, the trial chamber rendered on the 19th of August 2015 the impugned decision. It decides to grant in part the prosecutor's request to admit prior recorded testimony into evidence pursuant to amended Rule 68, paragraph 2C and D of the rules. On the 10th of September 2015, the trial chamber granted Mr. Ruto's and Mr. Sang's request for leave to appeal the impugned decision in relation to 7 issues. On the 5th of October 2015, Mr. Ruto and Mr. Sang filed the documents in support of the appeal, and on the 26th of October 2015, the prosecutor and the victims submitted their responses to the documents in support of the appeal. On the 12th of October 2015, the Appeals Chamber granted the African Union's request for leave to make observations under Rule 103 of the rules, which were then filed. I shall now turn to the merits of the present appeals. In relation to the first ground of appeal, Mr. Sang and the African Union submit that court officials gave undertakings to Kenya that amended Rule 68 of the rules would not be applied to the present case. The African Union also contends that certain state parties made unilateral declarations to the same effect. In her response, the prosecutor submits that she did not give any such undertakings. In addition, the prosecutor and the victims contend that the allegation raised by Mr. Sang and the African Union do not show an error in the impugned decision. As explained in more detail in its judgment, the Appeals Chamber considers that neither the text of amended Rule 68 or the rules nor the resolution of the Assembly of State Parties adopting the amendment make any reference to the amended rule not applying to a specific case or to pending cases more generally. The Appeals Chamber notes the emphasis placed by the drafters of the amended rule of Article 51, paragraph 4 of the statute, and finds that the text of the resolution expressly contemplates the amended Rule 68 of the rules may be applied retroactively, provided it would not be to the detriment of the suspect or the accused. Furthermore, the Appeals Chamber notes that no specific evidence has been produced to support the assertion that the explicit undertaking was given by the court officials. Neither is the evidence available reflecting a general intention by the state parties that amended Rule 68 should not apply to a specific case. Finally, in relation to the alleged statement by some state parties during the negotiation of amended Rule 68 regarding the understanding of the non-retroactive application of that provision, the Appeal Chamber observes that no documentary evidence is available to support the conclusion that other states agree to or otherwise endorsed these alleged statements. In addition, such agreement cannot be presumed from their silence. Accordingly, the Appeals Chamber does not find anything in the drafting history of amended Rule 68 of the rules to reveal an error in the conclusion of the trial chamber that the amended rule may apply in this case, subject to a consideration the requirements of Article 51, paragraph 4 of the statute. Turning to the argument relevant to the article, Mr. Ruto and Mr. Sang submit further under the first ground of appeal that the trial chamber erred in finding that Article 24, paragraph 2 of the statute only applies to amendments to provisions of substantive law, and that Article 51, paragraph 4 would be redundant if Article 24, paragraph 2 of the statute covered all amendments to the rules. Mr. Ruto and Mr. Sang also argued that the trial chamber erred in finding that amended Rule 68 was applied neither retroactively nor to the detriment of the person who is being inter alia prosecuted, as set out in Article 51, paragraph 4 of the statute. Mr. Ruto and Mr. Sang submit that the trial chamber erred in finding that the rule did not have retroactive effect because the prosecutor's request was, in the opinion of the trial chamber, not seeking to alter anything which the defense has previously been granted or been entitled to as a matter of right. Mr. Ruto and Mr. Sang further argue that the trial chamber erred by failing to undertake a case-by-case analysis in order to determine that the detrimental effect of the rule change. They further submit that detriment is established when the situation of a person in an ongoing case is altered to his or her disadvantage, damage, or harm. In their responses, both the prosecutor and the victims argue that Article 24, paragraph 2 of the statute only relates to substantive law and that it does not apply to the present case. Therefore, they argue that the trial chamber did not err in considering only Article 51, paragraph 4 of the statute. The prosecutor further submits that while Article 51, paragraph 4 of the statute applies to amended Rule 68 of the rules, its use was not prohibited in this case because the application of amended Rule 68 was neither retroactive nor to the detriment of the accused. The prosecutor argues that for the sake of legal certainty and fairness, Article 51, paragraph 4 of the statute requires an abstract assessment of detriment. She also submits that the trial chamber correctly interpreted the notion of detriment based upon a standard of whether the fair trial rights of the accused would be prejudiced, rather than one which merely considered disadvantage of the accused. The victims contend that there is no detriment to the accused on account of the mere introduction of the evidence. In its judgment, the Appeals Chamber considers that in light of its clear wording, Article 51, paragraph 4 of the statute is applicable to the circumstances of the present case, and further find that in principle Article 24, paragraph 2 of the statute concerns substantive law. The Appeals Chamber finds that even assuming that the law applicable referred to Article 24, paragraph 2 of the statute could potentially include certain procedural law as well as substantive law, this provision is not applicable to the amendments of the rules which are governed by the specific provision of Article 51, paragraph 4 of the statute. Therefore, the Appeals Chamber finds no error in the trial chamber's conclusion that Article 51, paragraph 4 of the statute is the appropriate provision to consider in the circumstances of the present case. Turning to the issue of whether amended Rule 68 was applied retroactively, the Appeals Chamber considers that in order to determine whether a procedural rule has been applied retroactively, it is necessary to determine the point in time at which the procedural regime governing the proceedings become applicable to the parties and in particular to the accused. For reasons explained in more detail in its judgment, the Appeals Chamber considers that at the commencement of the trial there was a clear procedural regime with respect to the introduction of prior recorded testimony on which the accused could rely. Therefore, the Appeals Chamber finds that in the case at hand, the date of the start of the trial is the appropriate point at which the procedural regime governing the proceedings become applicable to the accused. Accordingly, the Appeals Chamber finds that the amended Rule 68 of the rules was applied retroactively in the ongoing trial proceedings within the meaning of Article 51, Paragraph 4 of the statute. The Appeals Chamber observes that the Trial Chamber appears to have based its interpretation of detriment on prejudice to the rights to the accused. However, there is no indication, Article 51, Paragraph 4 of the statute, that detriment is meant to be purely limited to prejudice to the rights of the accused. The Appeals Chamber further notes that the text of Article 51, Paragraph 4 of the statute differs from that of the equivalent provision at the ad hoc tribunals, which expressly refers to the rights of the accused. For these reasons, the Appeal Chamber considers that the term detriment should be interpreted broadly and not be limited to prejudice to the rights of the person who is being prosecuted. The Appeals Chamber finds that detriment within the meaning of Article 51, Paragraph 4 of the statute is disadvantage, loss, damage or harm to the accused, including, but not limited to, the rights of that person. In that regard, the Appeals Chamber stipulates that it is not any disadvantage caused by the detriment of a rule that is sufficient for a finding of detriment under Article 51, Paragraph 4 of the statute. Detriment, in the sense of Article 51, Paragraph 4 of the statute, needs to meet a certain threshold, which is that the overall position of the accused in the proceedings be negatively affected by the disadvantage. The Appeals Chamber notes at the outset of the prosecutor's argument that the challenged evidence would have been admissible under Article 69, Paragraphs 2 and 4, or under Article 69, Paragraph 3 of the statute, even before the amendment to Rule 68 of the rules took effect. For reasons fully explained in its judgment, the Appeals Chamber considers that Rule 68 of the rules is an exception to the principle of orality enshrined in Article 69, Paragraph 2 of the statute. The Appeals Chamber notes that Rule 68 of the rules, former and current, sets out certain scenarios in which prior recorded testimony may be admitted into evidence. It follows that where the specific circumstances of a case fall within the parameters set out in Rule 68 of these rules, the legal requirements of that provision must be observed for the prior recorded testimony to be admissible. And those requirements are not met, recourse to Article 69, Paragraphs 2 and 4 of the statute is not permissible, given that such a course of action would render Rule 68 of the rules meaningless and would enable the party seeking the introduction of the evidence to avoid the stringency of the latter provision. As regards the prosecutor's further argument in relation to Article 69, paragraph 3 of the statute, the Appeals Chamber notes that the trial chamber did not address the issue of whether the evidence could have been admitted under Article 69, paragraph 3, before the amendment or Rule 68 in the impugned decision, nor was the Article 69, paragraph 3 of the statute a part of the relief sought by the prosecutor, an alternative request for admission. As such, any determination as to whether the evidence would or would not have been admitted under Article 69, paragraph 3 of the statute is wholly speculative, and therefore the prosecutor's argument in this regard will not be considered further. The Appeals Chamber notes that Article 51, paragraph 4 of the statute refers to application of an amendment to the rules. It follows that the assessment of detriment pursuant to this article involves not only an analysis of the amended law, but also how that law was applied in the particular case. The Appeals Chamber considers that the submission of Mr. Ruto and Mr. Sang, that they have suffered detriment, while relevant cannot without more be determinative of whether the amended rule was applied in the present case to the detriment of the accused. The Appeals Chamber notes that the prior recorded testimony admitted into evidence under amended Rule 68 in the present case would not have been admissible under former Rule 68 of the rules. Accordingly, in the case at hand, incriminatory evidence was admitted that could not previously have been introduced in written form. The Appeals Chamber considers that the prior recorded testimony was admitted without any proper opportunity for the accused to cross-examine the witness. The Appeals Chamber notes that some witness testified in court and recanted the content of their prior recorded testimony. In these circumstances, even if the accused had an opportunity to question the witness because they appeared before the court, the Appeals Chamber considers that in the absence of the prosecutor eliciting incriminating evidence from the witness and examination chief, such questioning does not amount to a meaningful cross-examination. It follows that evidence was admitted for the truth of its contents in circumstances in which those witness denied the allegation made, and that evidence and meaningful cross-examination was not possible. In conclusion, the Appeals Chamber finds that the application of the amended rule resulted in, first, additional exception to the principle of orality and restriction on the right to cross-examine witness, and second, as a consequence, the admission of evidence not previously admissible in that form under former Rule 68 of the rules or Article 69, paragraph 2 and 4 of the statute, which could be used against the accused in Article 74 decision. Considering these disadvantages, the Appeals Chamber finds that the application of this rule affected negatively the overall position of Mr. Sang and Mr. Ruto in the proceedings at hand. Accordingly, the Appeals Chamber holds that the Trial Chamber applied amended Rule 68 of the rules retroactively to the detriment of the accused. In applying the amended rule, the Trial Chamber committed legal errors in interpreting the notion of detriment too narrowly, it finding that the rule had not been applied retroactively, and in finding that this had not been detrimental to the accused. As it would not have been open to the Trial Chamber, for the reason outlined above, they admit the evidence under the former rule, the Appeals chamber considers that the trial chamber's errors materially affected the impugned decision. In light of the appeals chamber's conclusion in respect to the first ground of appeal, the appeals chamber need not address the remaining grounds of appeal. For these reasons, the appeals chamber decided to reverse the impugned decision to the extent that prior recorded testimony was admitted under amended Rule 68 of the rules for the truth of its contents. And this concludes my summary of the judgment. I thank the interpreters, the court reporters, and the session is now closed.
All rise.